Mar-A-Largo raid. Search warrant executed against a former president. Law in the news. The For Legal English podcast is now in session. On today's docket, we discuss the search warrant executed against the former president of the United States, Donald Trump. What does this mean for the rule of law? Will the details of the affidavit or the results of the search ever be revealed to the public? Will this be the new norm of the party in power using the courts and law enforcement to go after political opponents? Before we start the regular episode today, I wanted to update you on some changes. We're going to add a second episode to our weekly schedule. We'll have our normal episode in the beginning of the week, and then at the end of the week, we'll have a lexicon word of the week. This will be a shorter episode where we introduce a lexicon word, some important legal English term, and discuss it, give some examples of it. We hope this will be an entertaining as well as educational additional feature for the podcast. So stay tuned next week for our first lexicon word of the week. Enjoy today's episode. Welcome to the For Legal English podcast. This is the show for lawyers, law students, and other professionals from all over the world who want to improve both their legal English and legal knowledge. In this podcast, we discuss different legal topics such as law in the news, law in practice, legal writing, legal movies, and other issues. I'm Timothy Barrett, your host. I'm a former practicing attorney in the United States. Now I live in Tbilisi, Georgia, where I teach law and legal English. Go to our website, for, as in the number 4, legal English, no spaces or dashes.com. That's forlegalenglish.com. You can check out our blog articles, available courses, and the show notes for this episode. On the docket today, episode 20 of the For Legal English podcast. The Mar-A-Largo raid, search warrant executed against a former president. Law in the news. Background and prelude. Mar-A-Largo is a Trump resort and the official residence of the former POTUS, the President of the United States, POTUS, or FPOTUS for former. This is his official residence. While he was president, he moved out of New York and moved to Florida. Mar-a-Lago is a Trump resort, so he's often spent a lot of time there, but now it's his official home, his official residence. When a president leaves office, he often takes a lot of files with him. Some might be personal that he packed himself, or others that his staff kind of put together and sent to his future office, his future home, whatever it is. And this is always contentious. Do these documents belong to the president, or do they belong to the government? And of course, some may be attorney-client work product, which are privileged. We'll talk a little bit about that later on. And other documents might be classified or sensitive or secret, or were classified originally, but may have been declassified. And usually all these documents form the presidential library. The last several presidents, after they have left office, have formed a presidential library, which holds their records. And actually, these records at the library are under the control of the National Archives and the Presidential Library. So in the future, if any scholars want to go through these records, they can go to the Presidential Library and look at these documents, these letters, memos, whatever they are. And of course, there's also museum quality to the Presidential Library, where they'll have explanation of the president's life and his tenure as president. Before this raid, Trump, the National Archives, and the FBI, the Federal Bureau of Investigation, were discussing these documents, and it appears that he was cooperating. The FBI visited his office at Mar-A-Largo and even added a padlock. It doesn't appear to me by adding a padlock, it's going to be much more secure, especially when you consider this is the president's residence, so there are Secret Service everywhere, that sort of thing. So it doesn't seem like a padlock is the greatest security invention, but apparently that's what the FBI did. They wanted a padlock, so they added a padlock to this room or this office, something like that. But eventually the FBI changed course. Instead of cooperating, they went to a court and asked for a search warrant to seize these documents, to take these documents. And that's one of the remaining questions. It's not clear what, if anything, had changed. Had Trump or his lawyers refused to cooperate on some issue? That's unclear. It's also not clear that violating the Archives Act is criminal. In fact, another court found that it was only a civil violation, therefore not subject for criminal investigation. In any event, on the 8th of August, the FBI executed the search warrant. They searched the house, the residence of President Trump, when they knew he would not be there. He was traveling someplace else at the time. And normally, law enforcement should use the least intrusive means. In other words, asking to cooperate. If that doesn't work, maybe issuing a subpoena. But asking for a search warrant is certainly an escalation in that. It's kind of telling the court that we believe the target of the search warrant is not going to cooperate. If we don't execute a search warrant, this evidence or these materials may be lost. There have been some reports of some irregularities. Allegedly, the FBI agents would not give a copy of the search warrant when they arrived, which is clearly required. Apparently later they handed it over, but why didn't they hand it over in the beginning? Were they trying to hide something, or is this just FBI pettiness? Who knows? They also would not allow Trump's lawyers to watch the search. And another question is why? Was this just raw power? The FBI doesn't want anyone to see what they're doing? Normally, when local police execute a search warrant, the suspect or homeowner or their lawyer is allowed to kind of keep an eye on what they're doing. Now, they may have to do it from a distance. There may be a safety issue, but that certainly wasn't alleged here. But if that's not the issue, they should be able to kind of be out of the way and just watch what the law enforcement agents are doing. They also asked to turn off the internal surveillance cameras, which again is a little unusual, to hide their actions or what's going on. Now, the FBI is very secretive. As a matter of course, they don't record interviews and interactions with suspects in investigations, unlike local police departments. Local police departments usually record these things, and it can be used as evidence. In fact, over the last 10 years or so, most police departments in the country have started wearing body cameras, these like GoPro devices that they attach to the front of their uniform. And a lot of officers in a lot of departments were reluctant to do this at first, but for a lot of them, they've had great success with it because now the judge or a jury who's looking at that footage, that camera footage, doesn't have to take the law enforcement officer's word for it. They can look at the camera footage. However, the FBI is very reluctant to kind of adopt these modern day techniques, or perhaps just wants to keep their secrecy. The raid itself took several hours. They were there all day. And there are many FBI field offices throughout the country. I think there's over 50. But this was not like the Miami field office who was conducting the raid. This was done out of Washington, D.C. from a counterintelligence unit. And this is the same unit that was involved in prior investigations with Trump. And certainly you could make an argument that they have a bias against Trump. In fact, after the raid, one agent who worked in this unit, Agent Tybalt, was either fired or resigned under a cloud of controversy. It's not clear if he was connected with this search warrant or this investigation, but it is clear that he was involved with other Trump investigations. So it certainly likely had something to do with this case, but it's unclear how much. The magistrate judge. So what is a magistrate or a magistrate judge? This is not an Article III judge. This is not a judge that was nominated by the president and then confirmed by the U.S. Senate. It's also not an Article I judge either. In certain courts, like immigration courts, which are often called quasi-courts, they'll have a judge, but they're not an Article III judge. They're not nominated by the president and confirmed by the Senate. A magistrate judge is really appointed by the judiciary, usually by other judges within this district, and will have not a lifetime appointment like an Article III judge would have, but would have a limited appointment. Usually it's 10 years. It's kind of interesting, why didn't they have a regular judge and a full Article III judge, district court judge, handle this type of search warrant? Now, magistrates are limited to kind of minor things. According to the statute, they're limited to petty offenses, specific motions, and usually their decisions have to be later approved by the real judge. And also, if the parties consent, then they can use a magistrate. Why would they consent? Often district court judges have a very busy calendar, a very busy docket, so the case may move faster if they have a magistrate handle, a lot of the case. So parties may consent to that. Now, my opinion, and it's just my opinion for what it's worth, it's improper for a magistrate to handle this. This should have gone to a real district court judge, an Article III judge. When you're going after the former president, the leader of the opposition, the political party that's not in power, it just looks bad to have this magistrate judge issue, which is a very significant search warrant. Why not have a full judge make that determination? Although I say that, I don't think it's necessarily required by the law or the court rules for that to happen. But I certainly think that it would be a better path for the system to have followed. And certainly this reduces the trust in courts. Now, another concept is a duty judge, or in this case, a duty magistrate. So often in every courthouse in the United States, you'll have several judges, but one judge will be on duty. So if there is a search warrant or any type of emergency application, it will go to this specific judge. And it may be he's duty judge or she is duty judge for the day or the week, however that court sets it up. However, this does allow judge shopping. Normally, when you file a case, then there's some kind of system that randomizes which judge the case will go to. However, if law enforcement knows the duty judge schedule, then they can kind of manipulate that by, Judge so-and-so has the duty on this date, will apply on that date. Or, oh no, this judge has the duty today, we'll wait, we're not sure if he's going to approve this, we'll wait for, the next duty judge. So they can kind of do some judge shopping. The magistrate that signed the search warrant was Bruce E. Reinhart. He worked for 10 years as a Department of Justice attorney, then was in private practice for 10 years, and then in 2018 was appointed as a federal magistrate. And what also is kind of noteworthy or strange about this judge is he does have a connection to Jeffrey Epstein. If you're familiar with that name, he's a billionaire who's connected to many powerful and important people. And basically he ran a pedophile ring and had his own private island. While awaiting trial in federal custody, he died. Very mysterious circumstances. And it's obviously that he either was murdered or the Federal Bureau of Prisons is the most incompetent group of people ever. The cameras were supposed to be working. They were off. He was supposed to be in suicide watch, but nobody was really watching him. So they reported it as a suicide. And there's lots of memes about the fact that he didn't kill himself, for what it's worth. Now, is the connection important here? It's completely unclear. I'm not saying that it is necessarily relevant, but there are a lot of coincidences with those investigating Trump or before him, Hillary Clinton. You see many of the same DOJ lawyers or FBI agents or former DOJ lawyers, FBI agents. And it often makes you wonder, are there only like 50 lawyers in Washington, D.C.? Why do we see these same players again and again? And there's also been a complaint filed by a nonprofit or an NGO, basically pointing out that this magistrate had posted bad things about Trump on social media. And in fact, he recused himself in another case between Hillary Clinton and Trump. When a judge recuses himself or herself, that means that he's saying there's some kind of conflict of interest, so they're not going to handle this case. It would be improper to handle this case. Or there may be an appearance of impropriety, maybe out of abundance of caution, they would recuse themselves. So there's certainly nothing wrong with that. But we don't know why he recused himself in that case, and it certainly seems somewhat likely that whatever the factors were in that case might be similar factors in this case. So why didn't he recuse himself from this case? And records also reveal that he contributed to Hillary Clinton as well as Jeb Bush, who were formerly Trump's opponent. Certainly there is an appearance of impropriety. And this type of thing helps to reduce trust in the courts or in institutions overall. And also, why would a magistrate or a judge post anything political? It seems improper on its face. He was appointed as a magistrate in 2018. So why was he posting stuff that was political? Supposed to be impartial. After the search. So many groups asked for the search warrant and affidavit to be unsealed. So they motioned to the court for this to happen. Now, the search warrant itself is supported by an affidavit. The affidavit includes the probable cause. In other words, the why. The search warrant was released first, but really didn't have anything juicy or interesting. It was just kind of gave permission based on the affidavit. So it didn't answer any questions. At a court hearing, Magistrate Reinhardt heard arguments from the Department of Justice lawyers, Trump's lawyers, and these other parties that wanted to unseal these documents. And at the end, he ordered the DOJ, the Department of Justice, to submit a redacted version of the affidavit, basically saying that parts of the affidavit should clearly be released, although there were some parts that shouldn't be released. So he asked the DOJ to kind of propose what would be suitable to be released and what should still be redacted. If something's redacted, that means that it's blocked out, so that certain information cannot be read. Approximately a week later, that redacted version was submitted to the court, and the judge released it. The magistrate did not push back against the DOJ redactions, probably didn't even do an inquiry, why was this redacted, not that, just kind of accepted what was proposed and ordered that released. If you're enjoying today's episode, please subscribe. It would really help us out if you gave us 5 stars and a review. Remember to go to our website, 4 is in the number 4, Legal English, no spaces or dashes.com, 4legalenglish.com. Check out our blog articles, available courses, in the show notes for this episode. And I encourage you to comment. At the bottom of the show notes, you can leave a comment or ask a question. This is a great way to practice and improve your legal English skills. Our flagship course that we offer is Elemental Legal English. This is a completely online course that you can complete at your own pace. It has 12 modules, which normally would be a 12-week semester course. There's plenty of learning content, as well as exercises to reinforce what you've learned. If you're looking to improve your vocabulary or understanding of legal English concepts, this is a great course to get started with. If you go to our website, look for Elemental Legal English, and I'll leave a link in the show notes as well. The affidavit. So the first thing that you notice when reading the affidavit, if you are curious, go to the show notes. I'll leave a link there. You can read it yourself. But at the very top, the FBI agent who completed this affidavit and swore to this affidavit, his or her name is redacted. So we don't know who provided this information, the sworn statement, to the court. And in state court, I don't think this would ever be allowed. If this was an undercover agent, then certainly that would make sense. If there's some kind of extenuating circumstances, that may make sense. But it just seems like as a matter of course, the FBI wants to protect themselves from any sunlight, as it were. The affidavit itself talks about the National Archives and Records Administration, the NARA or NARA. And so this kind of puts to bed, at least it appears to, that the meat of this is not espionage or nuclear secrets, as was leaked to the press, that it might be something like that. Instead, it was just these presidential records. that when Trump was leaving office, he took 15 boxes from the White House and transported them to Mar-A-Largo. Like I said before, there's some dispute whether this is even criminal. Now, the search warrant is for a criminal investigation, criminal case. But the Presidential Records Act is not a criminal statute, and violations of that federal law don't constitute a crime. It's just a civil infraction. The affidavit itself claims probable cause for classified documents and obstruction of justice. From the affidavit itself, it talks about 18 U.S.C. 793, quote, whoever having unauthorized possession of, access to, or control over any document, close quote. But it's kind of interesting because the president had authorized possession of them when he was president. And so at what point does it become unauthorized? It's not very clear. In obstruction, it's kind of a weak argument. And often when law enforcement is kind of reaching, they go for obstruction. So it's not a very strong case on the face of it. Now, what is unauthorized possession? Who determines what is classified or not classified? According to federal law and regulations, there's lots of people and agencies that can determine if something is classified. But it's also very clear that a president can declassify anything. There is no higher authority, nor is there any protocol that a president must follow. A president has absolute authority to declassify documents. He can discuss classified information with foreign leaders. This may be wise or foolish, but certainly not illegal, and it's not espionage, despite what some have argued. The affidavit also includes a statement from Trump's lawyers, basically saying that the material in question was declassified by Trump when he was still president. So where is the probable cause? If this is not rebutted, then there really is no probable cause. So, of course, we don't know what's in the redacted sections, but there's nothing to really rebut this in the unredacted sections. So what are the claims? The claims are basically that there were mixed documents, that is to say, classified, non-classified material put together. And certainly this may be a legitimate claim, but really an administrative issue, not a criminal issue. Another claim was that there was an unsecure location or not approved location. And this seems kind of petty as well. It seems like certainly the former president of the United States should have a secured, approved location in his residence for these classified documents or sensitive information. But if he doesn't, it doesn't seem like you need a search warrant to fix that. You should just make sure that the location is secured and is approved. You should go through that process instead. But it's also surprising that he doesn't have a location like that at Mar-A-Largo, since he spent a lot of time there as president. This is not like a new home for him. And certainly as president, he went to Mar-A-Largo, I believe, much more often than he went to New York or any other place. So why wasn't there an approved storage facility for this sensitive information? Is that President Trump incompetence and his team, or is that government incompetence that this wasn't done or approved? That's not clear. The Privilege Review Team. So the affidavit itself admits that they may be seizing attorney-client documents, which would be privileged. These should not be seen by law enforcement officers. Attorney-client privilege is basically a privilege, a special right that the client has. It's not really the attorney's privilege, it's the client's privilege. That in common law system, we want to encourage clients to talk to their attorneys, to share information with their attorneys so that they can make proper decisions. Now, if the attorney has to turn over that information to law enforcement, then that's not going to lead to good attorney-client then that would destroy any attorney-client confidence, and it's going to encourage people not to talk to attorneys, and the result may be much worse, as a whole for society. So we want to kind of protect that attorney-client confidence by allowing this privilege. If an attorney, talks to his client or gets information from his client and gives legal advice, maybe he writes that down in a memo, a letter, email, whatever, then that is attorney work product, and that's usually privileged. Law enforcement is not entitled to that information. Now, the affidavit and the search warrant set up a privilege review team. Sometimes they'll use that term taint team. But it basically is a group of other law enforcement officers not involved on this case will review the documents and decide, is this attorney-client privilege, or is this something that the investigating officers can look at? Now, if you're hearing that, you may think, well, gee, that doesn't make a lot of sense. And I think you'd be right. I think on the face of it, this is a farce. This is not independent. There's no chance for an adversarial system. The client doesn't get to make an argument, explaining why this should be attorney-client privilege. Instead, it's just done behind closed doors by colleagues of each other. This is not an independent office. These are law enforcement officers that work for the same department. Over the last few years, a lot of things are different for Trump. This is not really one of them. This is kind of a standard FBI, DOJ protocol. But I would also argue in all those other cases, this is a farce. This is not a just way to do it. This is not an efficient way or even a reasonable way to do it. And in fact, the Department of Justice has already admitted to at least 2 instances where investigators saw what was arguably privileged documents. In fact, another story that came out was that Trump, I believe, claimed that they took his passports, and the FBI or the DOJ denied that, but then they later returned those same passports. So you have to be careful what you hear from those leaks. Trump's lawyers have asked for a special master to be appointed to investigate this or to look into this. A special master is somebody that is appointed by the court, usually the district court judge, to look into a specific question or a specific motion, specific matter. And sometimes it could be a magistrate judge, or it could be somebody else that is trusted by the court. And just like a magistrate or a judge, they should be impartial, which certainly law enforcement officers from the same department would not be. So Trump has asked that one of these special masters be appointed to oversee the document review. The Department of Justice has opposed this. The district court judge is considering this, but hasn't made a decision yet at the time of this recording anyway. But of course, justice delayed is justice denied. If that district court judge later appoints the special master, and it looks like they probably will, but it'll be after the DOJ has reviewed all these documents. So at that point, it's kind of like closing the barn after the animals have escaped. And certainly if the district court judge was considering this, you would think that they would order a halt to the privilege review team. Okay, stop working on this. Nobody look at them, and then, I'll make my decision, on this date or by this date. But that wasn't done. Observation of the affidavit. I want to talk about some points that I pulled out just by reading through the affidavit, or what I could read through the affidavit that wasn't redacted. So when it talks about property seized or the property that they wanted to seize, it specifically stated any presidential records, which kind of makes the argument that the former president of the United States doesn't have rights to retain their own records. We're not talking about just classified records or anything like that, but any presidential records. And we did talk about attorney-client privilege, but there's also executive privilege. That is, the executive branch, specifically the president, has certain rights and has to have some freedom and some confidentiality in order to execute the job. You can't always be looking over your shoulder or worried about what is going to be revealed. But in this case, at least, it seems like the courts are not entertaining any argument for executive privilege, at least so far. Another observation is that only one name was really revealed in this affidavit. And this was a former government lawyer. I believe he worked for the DOJ, but he spoke out in defense of Trump. And so that was the only name in the affidavit proper. Again, the special agent that signed the affidavit was not revealed. Other witnesses, sources, not revealed. So it's just kind of strange that they would reveal this one person who is kind of at odds with their views. So they don't mind revealing his name, apparently. And the redactions. This is a very heavily redacted document. I kind of counted through it, and I counted 14 pages that were fully redacted. The whole page, or virtually the whole page, was completely redacted. And there were 5 pages that were more than half redacted. And so there are 32 pages in the affidavit. That's over half of these pages. That's over half of the content as redacted. And you can certainly make an argument that this is an abuse of authority. Now, it makes sense to seal a search warrant before the execution. You don't want people to know about it before it's executed. They might move the stuff, whatever is being sought, whatever law enforcement is looking for. That certainly makes sense. But why after the fact? This should be open to the public. This reduces trust in institutions. The agent wasn't identified, no witnesses, and over half the affidavit was redacted. This is not really a fair or just system. There's no transparency here. It reduces trust in the judiciary, the Department of Justice, certainly the FBI, and really institutions as a whole. And this is banana republic stuff. This is the first time that a former president was searched, that his home was ransacked, that federal agents went through his home, and there's allegations they went through his wife's wardrobe or his son's bedroom and other things like that. Who knows what really went on in this raid, in this search. And of course, this is not just a former president of the United States. He is the leader of the opposition. He is the front runner in the 2024 election. And so what does that mean? It means that the party in power is investigating the opposition, or at least the leader of the opposition. And it's not surprising that more and more Americans don't really trust the DOJ or the FBI or even the courts, which is not healthy in the long run. Will Trump be indicted? So there are many pundits, political observers and commentators who are kind of arguing on both sides of this. Some may be pro-Trump or anti-Trump, alleged experts who are saying he's going to be indicted, he's going to be prosecuted for certain crimes. But there are also a lot of pro-Trump or anti-Trump that say the opposite. Nope, they're not going to indict, they won't prosecute him. So what's going to happen is really anybody's guess. From what we could see of the affidavit, it looks like weak tea. It doesn't look like they have a very strong case. And certainly to go after a former president, you would think that they would have a very strong case, to bring. If they do prosecute him, this would be very much like a Banana Republic style move. Already there's a widespread belief that there really are 2 legal systems, one for those favored by the government or the deep state, and one for everybody else. And if Trump were indicted or even convicted, it may not necessarily prevent him from running. He could still be on the ballots in most states and, potentially being elected. It might not have the effect that is desired by those in power. Which brings us to the next question. What's the political impact of this? We talked a lot about the law, but what's the political fallout of this? Before this raid, I think it's fair to say that Trump was a front runner for the Republicans in 2024, the next presidential election, but certainly not a certainty. There were some who wanted him, many, who didn't. Okay, let's move on to somebody else. Both Trump and Biden are much older than most presidents. Both of them have other issues as well. But after this raid, I think it's pretty clear that the party has gathered around him. Even those who had doubts or want somebody else have kind of gathered around Trump. And it seems like unless something else happens, he will win the nomination. He will be the Republican nominee. Or certainly it's his to lose. He'd have to make some kind of major mistake or some shocking evidence would have to come out that we certainly haven't seen in the last 5 or 6 years. But of course, it's 2 years away. So this November 2022, we have the midterm elections where all of Congress, the House of Representatives, are elected, and 1/3 of the Senate is elected, and many governors and other state and local elections are going on as well. In January 2024, the primary season begins. This lasts basically January until summer, and this is where the parties choose their nominee. And then in November of 2024 is the general election, where the next president will be elected. And then in January will be the inauguration when they actually take over. So what do you think? Was this a proper investigation, just proving that no one is above the law? Or is something crooked here, something not right? And what do you think the political effects will be? When we look back at this raid on Mar-A-Largo, maybe 2 years from now, or 10 years from now, or 20 years from now, what do you think people will think about? What will they remember? Lexicon. Let's review some of the legal terms that I discussed in today's episode. Magistrate, district judge, duty judge or duty magistrate, special master, DOJ, FBI, POTUS, P-O-T-U-S, or F-POTUS, F-P-O-T-U-S, probable cause, execution, as in the execution of a search warrant, privilege, attorney-client privilege, executive privilege, affidavit. Did you understand those terms? Were there other terms that I used that you didn't understand or had trouble with? If you have any questions, please leave a comment, ask a question in the show notes. Go to the website 4, as in the number 4, Legal English, no spaces or dashes.com. That's 4legalenglish.com. Check out our blog articles, available courses, and the show notes for this episode. Please comment. It's a great way to practice and improve your legal English skills. What did you think about this raid? Let me know in your comments. Please subscribe, give us 5 stars, and a great review. The For Legal English podcast is adjourned. Don't miss the next docket call.